May I please, Your Lordship?
Yes.
With the consent of other side, Lordship, I beg to mention item number 25, Lordship.
Yes. What do you want?
I want an adjournment, Lordship. I've taken the consent of other side.
Yeah, for what purpose?
So
This
for
contempt case.
Lordship, we are preferring a review petition against that order, Lordship. So we request some time.
From the other side.
Yes, sir.
On the request of Mr. S.S. Roy, Learned Counsel for the respondent number 2 made with the consent of the opposite party. This matter stands adjourned for 2 weeks. List accordingly.
Obliged.
May it please, my lord, I beg to mention one matter for withdrawal purpose, my lord.
When do you want?
And
Friday.
Tomorrow,
Friday.
highly obliged.
Lordship, with the consent of the other side, I beg to mention item 9. Lordship, we seek some additional time to file the affidavit, Lordship. 2 weeks may be granted, Lordship.
Malaj, I am for the petitioner in this matter, Malaj. This matter has been pending since 3 years, Malaj. If it is not inconvenient, can a date be fixed, Malaj?
Date will be in February.
Yes, Malaj, that will be.
Mr. I. Bhattakur, Learned Pending Counsel, PhD Department, Assam. 2 weeks time to obtain instruction and file affidavit in this case on behalf of the department. Mr. S. Vishwakarma, Learned Counsel for the petitioner, on the other hand, seeks posting of this matter on a fixed date. In view of the above, registered to list this case on 9th of February 2024.
May it please, Your Lordship. Pray for listing of writ petition, Lord. Any day after vacation.
Listing for what?
Writ petition for admission.
Obviously, you can't ask for a listing of a civil suit here,
Yes.
but for what purpose? Why are you mentioning it?
Because the respondent side has to file their affidavit in opposition, and because of that, the matter has been
You have a
pending.
mention memo, is it?
Yes, yes.
See, there is a column here, reason for mentioning.
It's written here urgent.
What is the urgent here?
There is no such urgency in this matter. But then,
Then it cannot be allowed.
any day after vacation.
No, you have to either change the mention memo or satisfy the requirement.
Okay.
Huh? What happened? You don't have any answer.
Oh, I mean, this
Find
was,
an answer and come back and mention, we'll allow it. But you have to satisfy the requirement of the mention memo.
all right.
You are yourself saying that there is no urgency. Then
Then the respondent had supposed to file an affidavit in opposition because of
that's
that.
right, but that's not a ground to mention.
Yes.
There are thousands of cases like that.
Yes, yes, madam.
Mentioning is a special provision.
Lord,
Case is pending, not listed. These are not grounds for mentioning. Do you agree or disagree?
Yes, I agree.
Apply your mind and come back. If you can make out a ground, I'll grant it. Yes.
Lordship, in a transfer matter, Lordship, there is a stay order in operation. We have filed an affidavit. Let it come on last week of any date on last week of
You
January.
first file the affidavit.
We have filed it, Lordship.
Mm.
We have filed the affidavit. Long back, Lordship.
You're for the department.
Yes, Lordship.
Actually, when do you want it?
Lordship,
When do you want it?
29th.
All right.
Lordship, I wish to mention one listing.
Just a
Lordship,
minute.
yes, Lordship.
Yes.
May I please, Your Lordship, I beg to mention item number 21 with the consent of other side. Lordship, I have received instruction in the morning itself. Lordship, 2 weeks time to file affidavit, Lordship.
On the prayer of Mr. B. Chaudhary, Learned SC, Agri Department, Assam, made with the consent of the other side. This matter stands adjourned for 2 weeks so as to enable the Learned Departmental Council to obtain instruction and file affidavit. List accordingly.
Obliged, Lordship.
Yes.
Lordship, I beg to mention one listing, Lordship, of a writ petition, Lordship. The matter relates to Lordship, Staff Selection Commission, Lordship. The similar matter has already been disposed of, Lordship, citing Gauravpadam's case, Lordship. On Friday, Lordship, if it's possible. Obliged, Lordship.
may it please, Your Lordship. Lordship, I beg to trouble your Lordship for listing of an IA. Preferably anytime as per your Lordship's convenience this week. The matter here, Your Lordship, pertains to initiation of a disciplinary proceeding based on anonymous complaint.
Hmm.
The guidelines are clear. The writ petition was filed in
22nd. Yes. 22nd.
May I please, Your Lordship, I beg to mention for listing, my lord. Related matter is on fixed on Friday, my lord. Let it be common.
What is the related matter?
Matter regarding termination, my lord,
Hmm.
of the petitioner service.
Petitioner was serving as what?
Service as a GRS, my lord. One is
Similar matters listed for what?
admission, my lord. On 112, my lord.
Which is the item number? You give it to her.
Not, it was fixed, my lord, not listed.
Then let it come in the list. Then you make a mention.
Most probably.
My lord, for item number 22, you may not like to take up the matter.
This before another bench without me.
Much obliged.
May I please, your lordship, I pray for listing an IA on Friday, lordship.
Why?
There is a small mistake in our plaint, lordship.
Hmm.
And this honorable court was passed an interim order. And due to this correction, lordship, this order was not complied.
No, it cannot be corrected. You file an amendment application. It is a mistake committed by you.
Yes, lord.
You have to amend your writ petition. It is not a mistake by a court, by the court. You make a mistake and the court cannot correct it like this. You have to file amended petition, amendment petition.
Obliged, lordship.
May I
Think
please-
about it and come back.
Obliged, lordship.
Lordship, I am paying for listing to read petition.
Hmm.
Matter relates to appointment of, on compassionate draft. Lordship, next week, any day.
Why it should be listed?
Lordship,
Why
there is,
next
petitioner is suffering from financial hardship.
No, but that's not a ground for mentioning. When was the case filed?
Lordship, it's a 2023 matter.
Then
Lordship, it was last.
you
posted on
wait,
7th.
come back in February first week if it is not listed. Yes.
May please, your lordship. Under the 2014 writ petition on last July, this honorable court directed for paper publication of private respondent, notice appointing private respondent. That was done. There are some matters have not been listed. Can it be taken off first week of or second week of February, my lord? Deeply.
May it please your lordship, I beg to mention for listing of a writ petition, your lordship, any day after BU vacation.
Why it should be listed?
Lordship, actually 116 posts were
No,
advertised.
no. You have a mention memo.
Yes, sir.
See what is written in the mention memo. Have you read it ever?
Yes.
Reason for mention, what is reason written?
Lordship, there is an urgency because the, we were selected, 116 posts were filled up, but we were not given the post. And subsequently, a new advertisement was issued.
So then you file an IA for interim order, that's not urgency.
Lordship, the matter last came up on 18/9.
Apply your mind and come back. You have to give a proper answer to the court. You are a lawyer, is it not?
Yes.
So the mention memo said reasons for mention, it's given. So you have to say that. The court has applied its mind, not granted interim order, they went ahead. What is the urgency? There is no urgency. The urgency must be a legal urgency, litigational urgency. Not that your client wants an answer early. That way, every case, there is urgency. Yeah, what
Lordship,
is your name?
AM DeCosta.
AM
DeCosta.
DeCosta. Have you understood what I've asked?
Yes, your lordship. I
So
will.
you apply your mind and if you can find a good answer, come tomorrow. I'm open to considering, but you have to give the answer.
Okay, much obliged, lordship.
May I please, your lordship? Lordship, I beg to mention item number 10, your lordship.
Hmm,
Yes, your lordship.
yes, what happened? You are facing some difficulty?
Yes, lordship. I met with an accident recently.
What do you want?
Lordship, a matter will be listed after ensuing Bihu vacation. Mr. A. Ganguly is out of
All
station,
right,
your lordship.
as paid for by the petitioner's counsel, this matter stands adjourned for a week. List accordingly.
Obliged, your lordship.
Item 1.
May I please, your lordship?
Hmm.
This contempt petition is preferred against the deliberate and willful non-compliance of the order dated 3/10/23, which is Annexure A, page 9. The relevant portion is at page 11. Last two.
Your name, please?
MR Sodiol,
MR Sodiol, 8 weeks.
deeply obliged.
Please, your lordship. Or it's a covered matter, connecting with the disabled persons matter. Series of matters to be disposed of.
Appearance. Give the appearance, please. This was similar order, this one. Ali was.
Obliged.
Party number लिख लो.
Wait, please, lordship. This selection by the SSC to the CIVF post, lordship. Covered by the lordship.
Award matter.
Yes.
Where is the judgment? CGC over table that. Mr. R. Sharma for petitioner. OBC category. OBC category. Sole petitioner. Disposed of. Hmm. Same order, huh? Disposed of. Get us order to be closed. Party number.
All right, that's. The petitioner is a branch manager of an LICI, my lord. He made a transfer from business side to Guwahati.
Is there any standing council of LIC?
No, my lord, there is no stand. Notice has to go, my lord. But in the meantime, my lord, since the letter of recovery has been given at page 47, my lord. 48, my lord, this may be stayed, my lord, because I am entitled to the amount as per the rules, my lord. My lord, may kindly see at page 34, my lord, the bill has been prepared, my lord. And it shows, my lord, transfer grant.
All right. Heard Mr. G. Alam, learned counsel for the writ petitioner, peruse the amendments made in the writ petition. The petitioner is entirely aggrieved by the communication dated 2/1/2024, bracket annexure 16. Bracket
Annexure
by means of which recovery of TE advance has been ordered by the authorities. First of all, Mr. Alam submits that the impugned order is illegal, and if not interfered with by this court, would cause serious prejudice to the interest of the petitioner. First of issue notice of motion returnable on 2nd of February 2024. Petitioner to take steps for service of notice upon the respondents by registered post with ID within 3 days from today. Within 2 days from heard on the prayer of interim relief, having regard to the facts and circumstances of the case, as an ad interim measure, it is hereby provided that operation of the impugned order dated 2/1/2024, bracket annexure 16, shall remain suspended till the returnable date.
My letter, my lord, actually is 48, my lord, 29/12, my lord. It is at page 49, my lord. It's letter, my lord, 29/12, my lord.
29/12.
Yes, my lord. Page, annexure 17, page 48, my lord.
Letter dated, letter dated
Letter dated,
29/12/2023.
23, my lord.
And the consequential communication
lord,
dated
my lord.
4/1/2024.
Obliged.
May please, your lordship. My lord, the petitioner was serving as a Circle Inspector of Assam Police. After an inquiry, he has been removed from service by the impugned order dated 17/7/23 at annexure 8, my lord. And we have preferred an appeal. This appeal is also not disposed of. So, my lord, at this stage, notice may go, my lord.
Mr. J. Patwari, learned counsel appearing for the writ petitioner, peruse the amendments made in the writ petition. By filing this petition, the writ petitioner is assailing the order dated 17/7/2023 passed by the authorities, imposing the major penalty of removal from service. Mr. Patwari submits that the appeal preferred by his client has not been disposed of till today. Mr. D. Bora, learned government advocate, Assam prays for some time to obtain instruction in the matter. NOM 6 weeks. You have all the response?
All the response.
Since Mr. Bora has appeared and accepted notice for all the response. No formal notice is required to be sent in this case. Extra copies of the writ petition. Requisite in numbers be furnished to the learned department counsel so as to enable him to obtain instruction. It is made clear that pendency of this writ petition shall not constitute a bar for the respondents to dispose of the appeal filed by the petitioner.
Election 9. Election 9 is the appeal. We have
Filed
annexed.
by the petitioner on merit, if so advised.
Give leave.
Item 6.
May I lordship, please? The petitioner made against the matter order of recovery, my lord. For vice for 1 year, my lord. Recovery is made on page 28, my lord. The order for recovery, my lord.
Page 28.
28, my lord. $7,41,114, my lord. It was recovered.
After 2019 order, now the petition has come in with our court.
And it immediately, but I have filed evidence on 20, immediately after
So
recovery.
we'll say no recovery if not already done.
My lord. The recovery is already done, my lord.
Already
It
done.
is his submission, Lord. It goes
Yes,
already
there
done.
can't be any stay.
No, stay matter, issue notice, notice.
All right, I heard Mr. A. Kanikol and counsel for the petitioner. Here is the amendments made in the writ petition. The petitioner has challenged the order dated 4/5/2019 issued by the superintendent engineer, North Kamrup Circle, bracket irrigation, Nalwari, ordering for recovery of an amount of rupees 7,41,114 as excess drawal from the pensionary benefits of the petitioner. Mr. Kanikor submits that in view of the law laid down by the Supreme Court in the case of Rafiq Masi versus State of Punjab. Is it syllabus or citation? You don't have the citation? You don't have the citation?
Right now, I've been seeing.
Right now. When will you have it? After the case is disposed of? Syllabus, State of Punjab was reported in France. Recovery on account of excess dwell from retired employees would not be permissible in the eyes of law. Mr. N. Upadhyay, learned SC Irrigation Department, has prays for some time to obtain instruction by contending that the recovery has already been made. In view of the above NOM 8 weeks since Mr. Upadhyay has appeared and accepted notice for the phone numbers
1, 5 and 6 Lord.
1, 5 and 6. Mr. Who is for the AG? What is your name? You are the standing counsel or who? Huh?
Aadhar, he is appearing on behalf.
Mr. Ardhar, learned counsel for respond number 2. Mr. A. Chalia, SC Finance for respond number 3 and 7. And Mr. C.S. Hazarika, learned G. Assam for respond number 4. Service of notice is deemed to be complete in this case. Extra copy of the writ petition, requisite in numbers, be furnished to the learned department counsel so as to enable them to open this action.
May it please your lordship. My lord, the petitioner before your lordship, my lord, he is an accredited engineer. He was working for 13 years and he was arrested in a criminal case and he was now dismissed from service without any inquiry.
Covered
My
case.
lord,
Covered case,
this
my lord. Your
may be, this
judgment is
case
there.
may be listed with along with 4182/2023, my lord. John Sequia case, my lord, I have referred, my lord. Lordship had fixed together, my lord. Connected matters, my lord.
We fix when?
Lordship, that matter was came up on 4th, my lord. Lordship has not seated on that day, my lord. That is why next date not fixed, my lord.
But is this case not covered by the earlier?
No, my
judgment?
Yes, sir.
Earlier judgment not covered in this matter. Lordship has,
There are a catena of judgment of your lordship, dishonorable as your lordship's order. This is the order in same department, my lord. Because without inquiry, without any so cause, my lord, I have been dismissed.
So, all right, we'll
My
discuss
lord,
it
let
after
him-
the admission stage.
My lord,
yes, yes.
I'm happy, my lord.
Heard Mr. T.J. Mohantal, our senior counsel, listed by Mr. D. Mohantal, and counsel appearing for the writ petitioner. Also heard Mr. S. Dutta, and SCPNR Department Assam appearing for the official respondent. The petitioner is aggrieved by the order of termination from service dated 14/12/2023, which was issued without serving any show cause notice upon the petitioner or
Without any DP, without any hearing the petitioner. Without any
giving any
department.
opportunity of being heard to the writ petitioner. Mr. Mohanta submits that the case of the petitioner is covered by several decisions of this court and therefore the matter can be disposed of. Mr. Datta, learned SCPNRD, however, submits that the petitioner's case is distinguishable on facts and therefore he seeks posting of this matter along with WPC number
4182/2023.
4182 of 2023. In view of the stand taken by the learned departmental counsel, this matter would require further examination. NOM 4 weeks since Mr. C.S. Hazarika, learned G. Assam has appeared and accepted notice on behalf of respondent number.
It's for 5, my lord. I am 1 to 4.
Mr. S. Dutta, learned SCPNRD for respondent numbers 1 to 4 and Mr. C.S. Hazarika, learned G. Assam for respondent number 5. Service of notice is deemed to be complete in this case. Extra copies of the writ petition be furnished to the learned departmental counsel, so as to enable them to obtain instruction. Register to list this case along with WPC number so and so.
Yeah.
We'll
Deep
dispose it of on the
My
next day.
Yes, yes. All right.
Supplementary list promotion item 24.
Meet your lordship. The matter relates to my lord, him listed day before yesterday, my lord. Relates to consideration of the case of the petitioners for promotion to the post from additional chief engineer to the post of chief engineer. DPC was credited set, but on that particular day, my lord, they considered for the post superengineer to additional chief engineer. But that was not done, my lord. It's so far this post is concerned. And this man, petition number 1, is retiring on 31st of this month, my lord. And then lordship has already passed one order in a similar matter, my lord, page number 19. And also, my lord, there is another, my lord, case of Syed Habibur Rahman of this lordship has passed the judgment, my lord, about the fundamental rights, paragraph 11, my lord. That's that copy, my lord. Paragraph 11, my lord, is the relevant part, my lord.
Yes, Mr. Nayak.
Lordship, they are already under consideration, Lordship. Only the 2 rounds of DPC took place, Lordship. Only question, Lordship, one of the person petitioner is retiring on 31st, Lordship. So that is, Lordship may pass a direction by disposing of this matter to consider and finalize the issue within a period of time, Lordship.
Just a small time frame, my lord, because ultimately
Within 10 days.
10 days, my lord. My
10 days, within 2 weeks, Lordship. Within
Bihu and then New Year is coming. There are
2 weeks
holidays.
there.
Put in 10 days, my lord. Let us see, my lord. Let us see. Because they are hope of a person working for whole life.
Lordship, Lordship.
Within 10 days after Bihu.
My lord, my lord. It will touch New 26 January again. My lord, I leave to lordship, my lord. My lord.
There are 2 petitioners.
Yes, my lord.
Take the
One
order.
is there in February.
Yes.
Say Amnath Ganesh, senior counsel listed by Mr. D.P. Vora, counsel appearing for the writ petitioners. Also heard Mr. P. Nayak, learned SCPWD Assam, and Mr. C.S. Hazarika, learned G. Assam, appearing for the official respondents. The 2 writ petitioners herein are holding the post of additional chief engineers under the Public Works Department, bracket PWD Assam. The petitioner number 1 is due for retirement on attaining the age of superannuation with effect from 31/1/2024, whereas the petitioner number 2 is due for retirement
31/5.
with effect from 31/5/2024. The grievance of the petitioners is that although there are as many as 5 vacancies in the rank of chief engineer available in the department, and notwithstanding the fact that several rounds of departmental promotion committee, bracket DPC, bracket close meetings have already been held for promoting superintendent engineers to the post of additional chief engineers. No such process has been finalized with regard to the vacant posts of vacant post of chief engineers, as a result of which the interest of the petitioners have suffered serious prejudice. Full stop. Mr. Nath submits that the petitioner number 1 is the senior most in the gradation list.
Second senior most.
Is the second senior most in the gradation list of additional chief engineers, and the petitioner number
Senior most.
2 is the 5th senior most in the said list. Therefore, since there are 5 vacancies available in the rank of chief engineer, PWD, and considering the fact that the petitioners come within the zone of consideration, the respondent authorities ought to have finalized the promotion process for filling up the vacant posts of chief engineers. First up, Mr. Nath has also invited the attention of this court to the order dated 16/6/2023 passed by this court in WPC number 3445/2023 instituted by petitioners seeking similar relief, as well as the decision rendered in the case of Syed Habibur Rahman versus State of Assam and others, third bracket WPC number 688/2014, to submit that the petitioners have a fundamental right to be considered for promotion, and denial of the said right would amount to violation of their rights guaranteed under Articles 14 and 16 of the Constitution. Mr. Nayak submits that the DPC process is under progress and a decision in the matter would be expected on any day. Therefore, he would have no objection if the writ petition is disposed of by providing that the case of the petitioners be considered in a time-bound manner. Full stop. In the case of Syed Habibur Rahman, bracket Supra, this court, while considering the right of a candidate of being considered for promotion, had made the following observations in paragraph 11, which is reproduced herein below. Report corridor. First up, I also find that there is no dispute about the entitlement of the petitioner of being considered for promotion to the post of Chief Engineer, PWD. First up, in view of the above, since the petitioners are due for retirement within retirement in near future, there is conceivable urgency in the matter, and therefore a writ of mandamus, in the opinion of this court, would lie, directing the respondents to expeditiously consider the case of the petitioners for promotion. First up, in view of the above, this writ petition stands disposed of by providing that within 2 weeks from today, the DPC would consider and finalize the and take a final decision on the question of promotion of the petitioners to the post of Chief Engineer, PWD. The decision be also communicated to the petitioners forthwith, that is within 2 days thereafter. With the above observation, the writ petition stands disposed of. Yes. Yes.
My lord.
Yeah.
I'm absolutely happy, my lord. Just, I'll be happiest.
You are always happy.
I'm always happy. I'll be
Nobody has
happiest.
ever seen you unhappy.
I'll be the happiest one. Just 10 days, 5 days. Just put the 10 days, my lord. Huge difference will come in his life. my lord.
Preferably within 10 days.
Lordship, one observation only. Their cases,
Expeditiously as possible, preferably within 10 days.
their cases will be considered along with all other eligible candidates
Yes.
who are already in the
There's
zone
no
of
doubt about it.
Along with other eligible candidates who are
Yes.
already in the zone of consideration.
Applies.
Who are in the zone of consideration. Writ petition stands disposed. A copy of this order be produced before the departmental authorities for necessary compliance.
Obliged.
May it please the lordship. The matter is regarding compassionate appointment, my lord. Petitioner husband expired on 6/1/2005 while he was discharging as a Chowkidar in the office of respondent number 7, my lord. And my lord, petitioner name has been recommended by the committee headed by Additional Chief Conservator of Forest, where petitioner name appeared as serial number 354, my lord. But by my lord, select list dated 18/7/2015, my lord, petitioner name did not reflected, my lord. And my lord, in the year zone of consideration 2005, my lord, the person who were selected, my lord, they were from different, my lord, different years, my lord. They are, my lord, regarding compassionate appointment, my lord. So and my lord, till that they have not submitted any affidavit, my lord.
Lordship, the petitioner husband died 2005, your lordship, and the select list which they have challenged, they have already selected, and they have not met parties. The person was selected in the compassion appointment. They're selecting the select list of 18/7/2015, where compassion appointment has already been granted to all this person, your lordship. They have not made a party in the
But
petition.
why the petitioner's case was not considered? The court would like to know.
Yes, your lordship.
This is not a civil suit. No, you say yes, but you don't have the answer. This is the
Most
2008
best
matter.
probably because the period of
No,
consideration for 2
we don't
years.
decide cases on most probably, most likely,
Yes.
perhaps. These are So who is the officer? Let him come and explain you. 2018 matter, 6 years have gone, no affidavit has been filed.
Yes, Your Lordship, 2008, we were not aware of this matter. It was our last occasion we just appeared in this matter, Your Lordship. So I'd like to take the instruction on this, Your Lordship. Kindly,
No, this is a case for personal appearance.
it's true, Your Lordship.
Mm.
But on the last occasion, we only entered appearance in this matter, Your Lordship. Because 2018 matter, we are not aware of. On last occasion, we were called for
We means you are for whom?
a forest department, Your Lordship.
No, but this is a BTC matter.
BTC matter, but the select
You
list-
will take another 1 year. And then after that say that it is not for us, the BTC. Then the BTC will come and say that now we are aware of this case. Give us another 6 months. Then after that BTC will file. This is how things are being dragged.
Lordship, BTC has provided conservator of forest, Lordship. Earlier, there was no, they have not considered in common DLC, Lordship. Earlier, forest departments, in internal department, DLC was considered, Lordship. Already the BTC has considered, Lordship. Now it is in, state level.
What BTC has recommended.
PCS,
Yes.
how they forwarded, and this
Right.
select list is been issued by the Chief Conservator of Forest, Your Lordship.
Correct.
Uh.
So why the petitioner's name is was not there?
So that I'll take instruction, Your Lordship.
Take it tomorrow,
Very well, Lordship.
day after tomorrow.
Obliged.
Yes, Mr. Pine.
May I please? Well, Lord, the petitioner before your lordship, she applied for the post of Anganwadi worker. And the, my lord, selected candidate on RTI, my lord, we found that she applied for the post of Anganwadi helper, not for the worker. But she has been selected for the post of Anganwadi worker. That is, my lord, your lordship will find her application on RTI,
So where
I-
is that statement in your writ petition?
my lord.
Have you stated that in your writ
Yes,
petition?
yes, yes,
Where
yes.
is that statement? Which para?
My lord, your lordship will find. My lord, your lordship will find, my lord, para 8, my lord.
Para 8. What is the relief you are seeking here?
My lord, first of all, my lord, second issue, my lord, my lord, your lordship may kindly see page 35 is the, my lord,
No, what is the
application.
relief you are seeking?
Relief I'm seeking for the, my lord, setting aside of the appointment of the private respondent.
Mhm.
And my lord, my name may be considered because two issues are there, my lord. First of all, in the advertisement, my lord, if your lordship go to advertisement, there was a column, my lord. The preference will be given to the female candidates having certificate of dance, music, sports and medicals. I have, my lord, I have some certificates from the, my lord, various colleges and authorities, various authorities of dance, music and sports. And these were not considered. Thirdly, my lord, while considering the selection committee, has just considered the certificates of the my lord higher secondary mark sheet. They have not considered anything other than the ACSL and higher secondary marks. That is in the RTI, but they have revealed that, my lord, your lordship will find page 34. The selection committee was there. They did not
Who is
consider
appearing for the private respondent?
private respondent. Nobody is appearing, my lord, despite of service.
Notice has been served.
Yes.
Yes, department has filed affidavit.
Yes.
What is your stand?
With regards to the statements made in paragraph number 8, which my learned friend has just shown, we have replied in a affidavit at page number 2. If your lordship may kindly peruse through affidavit, I'd just like to read out. Actually, there is no numbering for that particular paragraph. That with regard to the statements made in the paragraph 8, 9, 10, and 12 of the writ petition, the deponent states that an advertisement was published for 3 Anganwadi workers posts, including Boliza Koibua Anganwadi Center under Majuli ICDS project on 16/10/2020. There were 3 number of candidates for the post of Anganwadi worker at Boliza Koibua Anganwadi Center. On 30/10/2020 morning, Srimati Rumi Pegu submitted her application to the office of the CDPO Majuli ICDS project, indicating the post applied for as Anganwadi helper at Baliza Koibua Anganwadi Center. On 30/10/2020, on the same date itself, at 3:30 p.m., Srimati Rumi Pegu submitted another petition addressed to the CDPO with clarification and prayer to allow her to appear the interview for the post of Anganwadi worker at Baliza Koibua Anganwadi Center against the vacant post of Anganwadi worker. Here, if I may interrupt at this stage, your lordship, if your lordship peruses to the advertisement, which is at page number 26, that particular post advertised was only for Anganwadi worker for Baliza Koibua Anganwadi Center. Page number 26. The translated version is at page number 26 and the original is at page number 28.
Page
Serial
number
number
26 of the writ petition.
Writ petition, your lordship.
No, page number 26 is something else.
27.
In my writ petition is 26.
Page 27 it is translated.
The office circular 16/10/2020.
Anganwadi worker.
Anganwadi worker. So that's why she was allowed to apply for the post of Anganwadi worker and she was considered for the post of Anganwadi worker. Now, with regards to the second issue, as to the comparative statement, yes, the petitioner was earlier appointed, he was selected for the post of Anganwadi worker, being belonging since he was belonging to the physically disabled category. But later on, the director level at the director level, it was found out that that particular post was never reserved for physically disabled candidates. And earlier occasion, your lordship, perhaps my learned colleague on the earlier occasion could not place it before your lordship. The instructions were always there. I have flag marked, your lordship, certain particular pages would clarify the whole issue. With regards to the flag mark number 1 of those instructions, it's part of the notification dated 25/1/2019. And the relevant portion is clause 2, subclause 3, Roman 3. it says that 3% reservation has to be maintained for physically disabled candidates.
So the petitioner also applied for Anganwadi worker for this
Yes, my lord.
Bali Zokaibua.
Yes. He
Same.
applied for it.
There was only one post.
There was only
Only
one
one.
post.
One post, there can't be 3%.
That's
No, my lord, what my understanding is, in every center, only one post is available. In that case, there will be no reservation at all. Because it cannot be more than one post in a particular center. It should be seen within the, my lord, whether in the integrated, in that particular project, ICDS project, what numbers, if, my lord, my understanding is, calculation should be, my lord, done on the basis of, on the, my lord, entire numbers in the particular project, ICDS project. It cannot be on the, only on the particular center. One center, my lord, one Anganwadi,
So how many posts there are Anganwadi worker in that entire project?
that will be in, if it is on their calculation, my lord, I don't.
as for the advertisement, there was only one advertisement for the post of one Anganwadi worker. Now, as to the, now we have to look into the roster point as to whether that particular post for that particular Anganwadi center is reserved for.
These are not the cadet posts. This is us.
No, not cadet post. That's the problem here.
So 3% is not applicable here.
My lord, they have taken it, yes. My lord, probably there was a circular that, my lord, in the entire ICDS project, they will calculate it, then, my lord, 3% will be reserved. That may be there, I have gone through probably in earlier occasions, one circular was there. If they have that, my lord, whether it is there or not, I don't know.
My understanding, if I have to go by my understanding, your lordship, of this particular notification is for that particular advertisement, the 3% post. If suppose there are certain, say, 100 posts advertised, just for example, then out of those 100 posts, three posts may be reserved for physically handicapped candidates. But since there was only one post which had been advertised in this whole particular advertisement for Anganwadi worker, there was no question. So if I may take your lordship to flag number 3 of this particular set of instructions. That's the photo set is somewhat not clear, but it's a minus of the selection committee meeting after the approval for selection of the private respondent. And this particular issue as such was discussed as to whether that particular post was reserved for physically handicapped candidate or not.
Yes. Where is the disability certificate of the petitioner?
Yes.
Page 12.
No, but this does not mention percentage of disability. Is it so, Mr. Pang?
Yes, my lord. The nature of disability is there, percentage is probably not mentioned, my lord. RF,
So there is a benchmark disability to be eligible, is it not?
40%.
40%.
Yes, that is not there. No matter that is the second issue, my lord, whether it will be considered or not. My lord, initially, yes, my lord, initially they considered, but in the directorate level, it was, my lord, discarded. The second issue, my lord, what my second issue was, the, my lord, advertisement itself, it is given that if whoever, my lord, has the experience of music and, my lord, sports, they will be given preference. That part is not considered. not considered at all. And thirdly, my lord, is if my learned friend says, under the application, I file in RTI. In RTI, they did not give that result, my lord. In RTI, they have submitted me this application form only. My lord, in the application form, the private respondent applied for the post of Anganwadi helper. It is clear from the application form itself.
No, have you
Please.
filed any rejoinder against this?
No, I have not filed yet. Let me file a resign.
No, we'll, after hearing for 10 minutes, no question of will
No, my lord,
pass an order today.
actually,
You should have
last,
asked for that in the beginning.
last, well, last occasion, they asked for the, my lord, the application for the record of the application.
Mr. Pang, I think you should let go of it now. I have seen the matter.
Yes.
First of all, your understanding of 3% disability quota may not be correct. Because this act itself is a scheme.
Yes, it is a scheme.
In cadre post, 3% of the total cadre strength is to be reserved. These posts are to be identified. There has to be a special recruitment drive to fill up these posts through a different employment exchange. It is not like suddenly out of 10 posts, keep one and
Yes.
how will you do it? The physically disabled person cannot be subject to the same selection process, absolutely. So
Well,
I
probably
don't-
they
I
have
don't blame
notification.
you. The government departments don't also have the understanding.
The department has a notification to the defect probably, my lord. I have, what I have, I have seen it, my lord. There is a notification of their department.
So
itself.
that is another matter. Here, what is the ground to set aside the petitioner respondent's selection?
The first of all, my lord, they,
Your first ground is she did not apply for Anganwadi worker.
yes.
That is now demolished. They have stated in the affidavit.
But their affidavit, my lord, it is not, that's why last occasion the record was called for your lordship, whether that application, next application is legally my lord, permissible. Second thing, whether it is legally permissible.
Why not?
No, my lord, this is an application, whether there is a separate application form. If you file a different application for correction of this, that is a different issue, my lord.
Oh, no. The application was filed before 3:30 on the same day.
I understood, my lord,
Then
whether,
What is the, so these are not recruitment of ISRO scientists. They are Anganwadi. You see, unless there is a illegality in the process, how can the court set aside somebody's selection?
my lord, when I filed the RTI, I was given only this application, not that one, my lord.
That may be another case, but they have clarified that she applied and you have not rejoined.
I may be given 1 week's time, my lord, that I'll file a resign.
I will grant you, but
Yes.
these
And-
are not reasonable advocacy.
Yes,
Because
okay.
this matter will be dismissed regardless of what you did. I'm keeping in part her. See, you must let go of these cases. Once you know that there is nothing serious, just to cling on to a matter,
No,
this is
third,
not,
third issue,
this
my
is
lord,
not
that-
the sign of a fair counsel.
yes, my lord, third issue was, my lord.
You file your affidavit within 18th, we'll take up the matter on
Yes.
19th. And obviously it is heading towards dismissal, but you want to do it, you do it. Heard Mr. J.
Not on
Pang and
21,
counsel
but
for
can
the-
it be in the last week, my?
On 24th, also heard Mr. D. Boral and G. Asan has produced the record. On the request of Mr. Pine, this matter is directed to be listed again on 24/1/2024 as a fixed parted matter. You examine these things unnecessarily, don't cling on
Yes,
to
yes, yes.
something. Your clients may have their rivalry. Don't be a party to that. You're an
Okay.
officer of the court. If you don't have a case in merit,
Your lordship, can I take it back?
take back the record. There's
Yes.
nothing in this case.
Yes,
There's nothing.
only what if my learned friend, my lord, let me see if the, my lord, application of the second application can be furnished to me. my
Show
lord.
it to, show it to him. Where is the application?
It is not here in. it's not
Produce
here.
the second application.
Let him serve the second application, I may reply on that. Always.
May it please your lordship. Lordship, on last occasion, this honorable court has directed me to produce the original record, my lord. I have received the record.
What is
No,
this
this is a
record?
matter pertaining to selection to the post of motor vehicle inspector. My lord, what happened in this matter, the APSC issued an advertisement initially in the year 2020 for filling up of the post of motor vehicle inspector. Qualification prescribed was minimum qualification diploma in mechanical engineering and automobile engineering. Thereafter, they issued a corrigendum saying that degree holders will also be included, my lord. We participated, we applied, we were not allowed to appear in the examination. In that situation, we approached this honorable court. In the meantime, they canceled the, prior to approaching this honorable court, my lord, they canceled the earlier advertisement and they issued a new advertisement. After that, we approached this honorable court that we may be permitted to appear in the examination. This honorable court allowed us, my lord. And thereafter, results were kept in seal cover. And finally, pursuant to leave granted by this honorable court, results declared. Out of the 6 petitioners, my lord, 4 were selected. Now, as on date, the situation is, your lordships, 4 posts are kept vacant for the petitioners, my lord. That is the brief.
So what has happened to the recruitment process that has been completed?
Others are given appointment, my lord, barring 4. So I'll just take your lordships with the brief facts of the case, my lord. Basic issue is whether acquiring of degree presupposes the.
Where is the advertisement? Let us see.
The first advertisement your lordship will find page 23. Page 23. Name of post motor vehicle inspector under so and so. Number of post 26. The relevant portion will, your lordship will find the qualification at page 24. Minimum, page 23 down below, serial number 5, minimum essential qualification. All applicants must fulfill the essential requirements of the post and other conditions stipulated in this advertisement. They are advised to satisfy themselves before applying that post. At least essential qualification laid down for that post. No queries will be entertained related to the eligibility criteria by the commission. Then page 24, your lordship will find HSSLC with 3 years diploma in automobile or mechanical engineering from a recognized institute of Government of Assam, Government of India, also duly recognized by AICTE. Note 1, the prescribed qualifications are the minimum and the mere possession of the same does not entitle candidate to be called for interview. Then your lordship will kindly come to note 2. The candidates applying for the post should ensure that they fulfill all the eligibility conditions for recruitment to the post. If on verification at any time before or after the interview, it is found that they do not fulfill any of the eligibility conditions, their candidature for the post will be cancelled by the commission.
So what is the issue here? Your clients are graduates.
Yes, my lord. My clients are graduates. They are, my lord, degree holders in the respective discipline, my lord. They were initially, my lord, not permitted to appear in the examination. Your lordships permitted. Now, issue here.
How can they appear?
No, thereafter, yes, my lord. I'll just come, my lord. Then your lordship will kindly come to page 30, my lord.
We'll come to everywhere you want, but you first come to the point.
This advertisement was cancelled thereafter.
Then
they have issued a corrigendum after this. That your lordship will find page 30.
Page 30, okay. Yes.
In continuation of the office advertisement dated so and so in pursuance to the government letter number so and so, it is for information to all concerned that the educational qualification for the post of motor vehicle inspector under the Commissioner of Transport Assam under Transport Department may be read as under HSSLC with 3 years diploma automobile mechanical engineering or BE BTech automobile stroke mechanical engineering from a recognized institute of Government of Assam, Government of India, and also duly recognized by AICTE. The intending candidates meeting the above mentioned modified educational qualification can apply. After that, we submitted our candidature.
So what is the qualification of your clients?
my lord, BE in mechanical and mechanical engineering.
They are BE in mechanical engineering.
Yes, my lord. From Guwahati University. My lord.
Then why they have not been allowed to participate?
My lord, what thereafter they issued an advertisement, page 32. They cancelled the previous one
Yes.
and they issued this advertisement. Page 32, serial number 5. They again restored this diploma.
Yes.
Then we approached this honorable court saying that since we have got the degree in mechanical engineering, so it presupposes acquiring the lower qualification of diploma. And this honorable court allowed us to participate in the examination and results declared, we got selected, 4 of us got selected.
So what happens to the earlier advertisement, Coriandum?
It was cancelled, Lordship, page
Original-
31. Page 31, yes, earlier was cancelled now.
So you wanted HSLC, HS with 3-year diploma and they are bachelor
Graduate.
of.
They are graduate.
So what is the problem? If the
Lordship,
graduates-
as we have to go by rules, my lord. The service, Lordship may kindly have a look at the service rule, page 54.
Hmm. Yes.
Lordship, the motor vehicle inspector, my lord had got it, my lord. ASSLC with 3-year diploma in automobile or mechanical engineering from a recognized institute of Government of Assam, Government of India, and also duly recognized by AICTE, Lordship. This is the prescribed qualification as per
So this
rule.
is
my
the
lord.
minimum qualification.
The minimum mode is not here, my lord.
Oh, where does
That
it
is
say
the
someone having more qualification will be debarred?
But Lordship, we have taken view from the judicial department. That's why this honorable court has directed
No,
us to
no,
produce the
there is, for example, in this high court, there is a rule
Lordship.
that if you are 10+2 pass,
Lordship.
then you cannot be appointed for a grade 4 post. But that is because there is a provision in the rule which says beyond that you are ineligible. A graduate cannot join in a grade 4 post. Is that correct?
Yes, my lord, absolutely. My lord, several litigations are coming up before your lordships in this bench.
That
Of
has
that.
to be specifically provided.
It's
For example, to participate in the APSC exam, the qualification is degree,
Degree.
but
Lordship.
a PhD holder cannot become a
Yes, they can, they are eligible, my lord. But Lordship have to decide whether the diploma in automobile or mechanical engineering is the basic of the.
No,
That is.
it does not debar. This is the minimum prescribed qualification. Your advertisement itself says this.
Lordship,
Look at your advertisement.
my lord, page 32, my lord.
Yes, not 32.
Lordship.
First one,
No, the second one, my lord.
page 24.
32, my lord.
24. First look at 24.
24, Lordship. The
Yes,
first one, my lord.
Note one. Read it, please.
24, my lord. The prescribed essential qualifications are the minimum and the mere possession of the same does not
Yes.
entitle.
This is the
This
minimum.
word is there.
Huh?
Yes, Lordship. The minimum word is there, my lord. Note 1.
Correct.
Yes. But this advertisement was cancelled by
Maybe, but then you restored the same advertisement again.
No, sir, we have issued that corrigendum for 31, Lordship, page Lordship 30. We are allowing the degree holder to participate in this selection process. But we have taken views from the judicial department. Their views is that without amend the service rule, we cannot allow them to participate. That's why we
They are
have
not
cancelled.
concerned. Judicial
Lordship.
department, they are free to give their view.
Lordship.
They are only concerned about what is the edict of law.
Yes.
You please answer this question. And
Lordship.
you may have an answer.
My
If you
lord.
don't, then we'll pass an order.
My lord,
If you have, then we'll consider it.
lordship.
There are
Lordship,
many such posts where the minimum qualification is prescribed. You can
Yes.
become an IAS officer with a degree,
lordship,
but a PhD holder cannot become an IAS officer.
lordship,
So this is a completely
yes.
irrational logic.
Lordship, I understand, my
Even
lord.
your officers have understood this.
Yes.
So
That's why they have,
they have mentioned that it is a minimum qualification.
yes, lordship,
What kind of a system is this where you are giving
yes,
priority to diploma holders and ignoring
yes.
graduates?
Degree holders.
Degree holders? What is the
Yeah.
message you are sending?
And the higher post is also they
Just
want.
take a
I'm-
seat
I'm
now.
Lordship, I understand that, lordship.
No, but if
But-
you understand, then you have to address the court on that.
Yes, but lordship, I am relying on judgment of the Honorable Apex Court. Lordship, may kindly have a look, lordship. Page, same fact, similar situation, my lord. Relevant is paragraph 26 and 27. May I read, lordship?
Yes.
Ek minute, Anna. Yes, so. My lord had got it, lordship.
Yes, please.
We are in respectful agreement with the interpretation which has been placed on the judgment in Jyoti KK in the subsequent decision in the Anita, the decision of Jyoti KK turned the provision of rule 10A to absent such a rule. It would not be permissible to draw an inference that a higher qualification necessarily presupposes the acquisition of another, albeit lower qualification. The prescription of qualification for a post in a matter of recruitment policy. The state as the employer is entitled to prescribe the qualification as a condition of eligibility. It is no part of the role or function of judicial review to expand upon the ambit of the prescribed qualification. Similarly, equivalence of a qualification is not a matter which can be determined in exercise of the power of judicial review. Whether a particular qualification should or should not be regarded as equivalent is a matter for the state as a recruiting authority to determine. The decision in Jyoti KK turned on a specific statutory rule under which the holding of a higher qualification could presupposes the acquisition of a lower qualification. The absence of such a rule in the present case makes a crucial difference in the ultimate outcome. In this view of the matter, the division bench of the High Court was justified in reversing the judgment of the learned single judge and in coming to the conclusion that the appellant did not meet the prescribed qualification. We find no error in the decision of the division bench, my lord. Then 27. While prescribing the qualification for a post, the state as employer may legitimately bear in mind several features, including the nature of the job and aptitude requisite for the efficient discharge of duties, the functionality of a qualification, and the content of the course of studies which leads up to the acquisition of a qualification. The state is entrusted with the authority to assess the needs of this public service, exigencies of administration. It is the tried law that fall within the domain of administrative decision making. The state as a public employer may well take into account social perspective that require the creation of job opportunities across the social structure. All these are essentially matters of policy. Judicial review must read warily. That is why the decision of Jyoti KK must be understood in the context of a specific statutory rule under which the holding of a higher qualification, which presupposes the acquisition of a lower qualification, was considered to be sufficient for the post. It was in the context of specific rule that the decision of Jyoti KK is turned. So, lordship, this case is similarly situated in the present situation, my lord.
Yes, Mr. Das, you see, you will have a roadblock here. The analogy of graduation master's degree as employed by this court perhaps will not be appropriate in this case. Because to become a master's degree holder, you have to have a graduation. But your clients will have to have a 3 years diploma in that process. Apart from that, if they are graduate Bachelor of Engineering holder, then the matter is different. But the fact is that they do not have the prescribed qualification as per the rules. They are not 3-year diploma holder.
No.
Then they may be master's degree or even doctorates. But they don't meet the qualification under the rules. That's what our argument is.
Yes, Milord.
That's what appears to be.
Milord, there are judgments of this honorable court and apex court also. Milord, this judgment relied on by my friend, Milord, tried to distinguish Jyoti KK, but on the given facts of the case.
No,
But
it does not distinguish. It follows courts with approval.
yes, so far as the proposition of law is concerned, the state is the authority to prescribe qualification. Milord Jyoti KK also and affirms that aspect of the matter.
See,
I'll
please,
just place Milord Jyoti
please
KK,
understand the query.
Lordships.
You can place whatever you want to.
I
There is
understand.
no difficulty.
Yes, Milord.
See, look at a situation where they say that minimum qualification is a bachelor's degree. So we'll not allow a master's degree to participate. That would be a different matter because to become a master's degree holder, the persons will have a bachelor's degree. So they have the minimum qualification, but more than what is required.
Yes.
Here, the bachelor's degree is higher qualification than diploma holder. But they are not diploma holders, which is the qualification prescribed under the rules.
Lordship is correct. They are not diploma holders. But Milord, I have annexed a notification of AICTE, Milord, wherein it has been provided that diploma holders can also make a lateral entry to the degree holder course. After 1 year in degree course, a diploma holder can make a lateral entry. So a diploma holder can enter into a degree level course. And in that context, Milord, the proposition I am arguing is that, Milord, a degree holder can be equated, or even if it's a degree holder is a higher post, even then it presupposes holding of a lower qualification, holding of the diploma qualification. This honorable court, as well as Milord Meghalaya High Court and Jammu and Kashmir High Court, Milord decided on this issue relying on AICTE. But this was not argued. This argument regarding the AICTE's notification was not argued before Supreme Court, Honorable Supreme Court in the case cited by my friend. I'm just placing, Milord, it has to be there in the records, Milord. First of all, I would like to take your lordships with the
Yes.
decision in Jyoti
This
KK.
matter will take some time.
Yes,
We'll
Lordship.
have it on a non-miscellaneous day.
Lordship.
But
Milord,
because
there
this
is-
is a hurdle you will have to meet.
Milord, I can cross this hurdle, Milord. In fact, if your lordships considers Jyoti KK, apart from what has been discussed in Jarur Ahmed, Jyoti KK also specifically says that if
We'll have it on 1st February.
1st of February.
Yes. 1st of February.
Can it be 6th of February?
Huh?
6th of February,
Why?
February 6th.
Why?
Okay, I will argue this case, Lordship, on behalf of Tija Mohanto. I may be out of session on first.
You may be,
Maybe.
but you may not be also. You're not sure.
I'm not sure, Lordship.
Cancel your trip. Go on 6th. Yes, because 6th is a better day to travel. We'll see. Let it be on 1st. We have to space out our cases to write out judgments. See, the core issue here will be simple. You have to show that your clients did hold the prescribed qualification as per the rules.
Yes.
Whether from here one can go there, from there one can go here is another matter. But perhaps in this judgment relied upon by High, the Supreme Court has been very clear
Yes.
that even if the prescribed qualification is lower, it is a separate qualification prescribed by the rules. So you have to have that. Supposing your clients had completed 3 years diploma and then gone on to become a BE and a master's degree, and then they said that no, we'll not allow you. Then the argument you're trying to advance, prima facie, would straight away come in that I may have more qualifications, but I have the minimum qualification. But here is the case, you yourself admit that your clients did not have the prescribed qualification. And therefore, the qualification prescribed by the rules, they did not meet. They did not meet. For example, a PhD degree holder cannot be appointed as a grade 4 employee in the High Court. It cannot be.
That
yes.
I understand.
Yes,
But
so merely because somebody is more qualified.
that rider has to be there in the rules.
That's because there is a rider.
And Honorable Apex Court, Milord, subject to correction, Milord, Honorable Apex Court has said that since there is no restriction in the rule, you cannot restrict the person.
No. Restriction in the rule is one thing. But as I said, again, at the cost of repetition,
I'm
we
sorry.
will close it here for now.
I'm sorry.
You have to show that they fulfill the qualification of, you know.
I'll satisfy, Lord.
that
I'll
level.
satisfy. I'll
All right.
satisfy.
So and so, so and so, so and so. Miss Bora Lanet,
Standing Council Transport.
Standing Council Transport Department Assam submits that she has received the records
Yes.
and therefore the matter be taken up for final disposal. In view of the above and considering the urgency involved in this matter, this writ petition is directed to be listed as a fixed item on 1/2/2024 in the admission column.
Lordship.
Lordship,
Keep your
will
Taken
pleasure.
up for final disposal in the
Lordship.
next 8 weeks.
For further hearing, Lordship.
Yes, yes.
Part heard, no? Lordship has heard.
Deeply obliged.
Yeah, if you have any difficulty, we'll see.
Lordship will
Don't
keep it.
cancel
as-
your trip.
Lordship will keep it as part heard.
It will be part heard.
Mild.
I'm not going anywhere. also. Unless you want to send me somewhere.
Obviously not.
Obliged, my lord.
No, this matters has become infructuous. Your Lordship will remember APSC matter, your Lordships allowed us to appear in the examination, they failed me, Lord. Lordships gave us a chance.
HK Das, Lanet Counsel for the writ petitioner in both this writ petitioner. Writ petitioner in item number 13 and
Yeah.
Mr. KP Pathak, Lanet Counsel for the petitioner in item 14 submits that although the petitioners were allowed to participate in the selection process, when the results were declared, they emerged as unsuccessful candidates. As such, nothing survives for adjudication in this writ petition. Mr. PP Datta, Lanet SC, APSC, and Mr. D. Bora, Lanet G. Assam, appearing for the official respondents, have also agreed to the said progression. As such, both these writ petitions stand disposed of as infructuous. Interim order passed earlier shall stand vacated.
Highly.
May I please, your
16
Lordship?
to 18,
Lordship, I was directed to file one affidavit, my lord, bringing the model form, my lord. I've received the model form, my lord, and need 7 days time to file it, my lord.
What are these matters?
Whether it's contractual matter, my lord. After giving the so cause notice, they have filed a reply thereafter termination, my lord.
My lord, the issue is different, my lord. What had happened, your lordships has disposed of a series of petitions where lordships has held that there was a requirement to follow the principles of natural justice before terminating. Now, a coordinate bench of this honorable court, though at a later point of time, has taken a contrary view. It is in that context, lordship asked us to address on that point. Nothing to do with form and all, my lord.
Lordship may kindly go to the last order, my lord.
Mr. Chaudhary, what we'll do is, on 8th, you will be in a better position to argue these cases.
Yes.
Perhaps the Leonard single judge's order appears to be per inferium. So we have to deal
And
with.
we have brought those full bench judgment of our High Court, my lord, when a judgment can be construed to be a judgment per incuriam.
But then it was not pointed out. It was
My
not
lord,
raised
may I
by
submit one thing, my lord? These matters, my lord, that order will, we are not on relying on that order, my lord.
No, when will you file your affidavit?
Within 7 days, my lord.
If you don't file it.
Yes,
you have
yes.
right to file affidavit.
My
in
lord,
same
my lord,
stock.
my lord.
And we'll have it on 8th. Mr. Chaudhary, 8th suits you? 8th of February?
Yes,
My lord.
8th of February.
Suits you?
Yes, yes, my lord.
Yes.
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 8th of February.
I had Mr. K. N. Chaudhary and senior counsel listed by Mr. R. M. Dekal and a counsel appearing for the writ petitioners in this batch of writ petition. Mr. S. Datta, Leonard SC PNRD submits that he has received instructions, but due to paucity of time could not file the affidavit, assuring this court that affidavit on behalf of the department covering the issue involved, covering the issues involved in these proceedings will be filed within 7 days from today. Mr. Datta has sought posting of these matters again in the first week of February. In view of the assurance, in view of the request made and the assurance given by the Learned Department of Counsel, these writ petitions are directed to be listed again on 8/2/2024 for admission hearing as fixed items by tagging the affidavit, if any, filed by the departmental counsel. It is made clear that if no affidavit is filed within 7 days from today, the respondent shall be debarred from filing affidavit.
My
on the
lord.
matter.
15, 16, 17, 19 and 20. Same. 15, 16, 17, 19 and 20.
Deep drop.
All right.
Item 18.
Look, some instructions were sought for. It was a simple issue, my lord, relating to unfitness of the petitioner. During the recruitment, really, he was found unfit. Then, my lord, from the civilian doctor, he obtained an opinion which says fit. So therefore, my only limited prayer is that it should be reviewed, my lord. If unfit, my lord, unfit, my lord, if fit, I am found fit. Similar orders have been passed in other cases also. That is my limited prayer, my lord.
Do you have a copy of the order, similar order?
My lord, lordship would see at Annexer 10, page 34. He was asked to, my lord, appear in a review medical board, my lord. Page 37 is the effective part, my lord. Of course, it says that it should not be treated as a precedent, my lord, but then
Yes, what do you have to say, Mr. Datta?
my lord.
Agreeable to the order?
Yes, my lord.
Had Mr. B. Pathak, Learned Counsel appearing for the writ petitioner, also had Mr. A.K. Datta, Learned CGC appearing for the respondents. Full stop. The facts of the case, in a nutshell, is that the respondents had issued an advertisement notice dated. What is the date of the advertisement notice?
Advertisement dated is, my lord, Annexer 1.
Advertisement date cannot be annexure 1.
15th February 2023.
15 to 2023 for conducting recruitments for filling up the post of Havildar /Clerk in the Assam Rifles Technical and Tradesmen Recruitment Rally 2023-24. First up. The petitioner belongs to the OBC category and he had participated in the said recruitment process. Whereafter, he emerged as a selected candidate. However, the petitioner was denied appointment letter on the ground that he was found to be medically unfit by the
Medical board, my lord.
medical
Annexer
board.
Any review
constituted
board
by the-
also.
Huh?
Any review board also.
Medical board constituted by the respondent authorities. The finding of the medical board was subsequently affirmed by the review medical board.
Yes.
Full stop. Thereafter, the petitioner approached a private practitioner, is it?
No, my lord, it's a government hospital, my lord.
Petitioner approached a medical practitioner in a government hospital, namely
Sawai Mansingh Hospital, Jaipur.
Sawai Mansingh Hospital, Jaipur, and obtained a certificate according to which the disability in petitioner found by the Departmental Medical Board was not proper, full stop. In other words, according to the petitioner, he was erroneously found to be medically unfit, full stop. Under the circumstances, the petitioner prays for an order from this court directing the respondents to subject him to a fresh medical board so as to assess his physical condition for the purpose of considering as to whether the petitioner deserves to be issued the appointment order. First up. In support of his above argument, Mr. Pathak has invited the attention of this court to the order dated 27/5/2022, passed by the learned single judge in WPC number 2803 of 2022, wherein a similarly situated candidate was granted the relief as prayed for by the petitioner. Full stop. Mr. Pathak submits that the present is also a fit case where a fresh appeal / review medical board be constituted to examine the medical fitness of the petitioner in a time-bound manner. Full stop. Mr. Datta submits that since similar orders have been passed by this court in case of similarly situated candidates, he would have no objection if the present writ petition is also disposed of with such an order. Full stop. I find from the record that the petitioner in WPC number 2803 of 2022 was also a candidate who had participated in the Assam Rifles Technical and Tradesmen Recruitment Rally 2021-22 against unreserved category vacancy for the state of Telangana. Full stop. He emerged as a successful candidate, but was denied appointment order on the ground that he was found to be medically unfit by the Departmental Medical Board. Full stop. Agreed thereby, the petitioner had approached this court by filing the aforesaid writ petition, which was allowed by the learned single judge with the following directions. Page 37. Page 37, para 10, 11, 12, and 13. Full stop. Since the petitioner's case is also standing on equal footing, and the learned departmental council has agreed to an order being passed in the present proceeding in terms of the earlier order of this court, this writ petition stands disposed of by providing that a fresh medical public review board be constituted for us to so as to examine the physical condition of the petitioner, full stop, medical condition of the petitioner, and thereafter his case be processed in terms of the guidelines laid down in the judgment and order dated, whatever dated so and so, passed in WPC number so and so, as expeditiously as possible, but not later than 4 months from the date of receipt of a certified copy of his order. Writ petition stands disposed of.
Clear.
For orders, item 23.
But the petitioner was supposed to take instruction, my lord. My instruction says that already the petitioner has been appointed and he has joined in his service in the month of September 23.
None appears for the petitioner. Mr. D. Nath, learned counsel for the respondent, submits on instruction
Sorry,
that
September 22.
The petitioner has already been appointed on compassionate ground.
Yes, my lord. On
And he has joined service in the month of September. Yes.
22.
Your client has joined.
Client has joined, but
Ah.
instead of forget. My lord.
All right.
It's a compassionate appointment.
You're right. Mr. Aram Chaudhary, learned counsel for the petitioner is present. Mr. D. Nath, learned counsel for the respondent, submits an instruction that the petitioner has not only been appointed against a grade 4 post on compassionate ground, but he has also joined service in the month of September 2022. Therefore, the order of this court has been complied with. Mr. Chaudhary, learned counsel for the petitioner, has also confirmed the said position. In view of the above, this contempt case is closed. Third grade, fourth grade, it is compassionate, you can't choose.
Item 24.
May I please, your lordship, service completed lordship 8/1/2024 lordship. Implement manager and deputy commissioner Shivsagar as a party respondent. Lordship.
Mr. Nath. Mr. D. Nath. This contempt cases, nobody appears. Despite service of notice.
Hey, deputy commissioner Shivsagar.
Number control, item number
24.
24.
Mm.
But name has not been shown. I have to check whether the service has been complete or not.
Completed lordship. Complete 8/1/2024.
But Mr. K. R.
I'll take it.
Perused office note dated 8/1/2024, which goes to show that service of notice is complete on respondent number 2. However, none has appeared for the respondent.
Give me 1 week time, my lord.
On the request of Mr. D. Nath Leonard, Senior Government Advocate Assam, this matter is directed to be posted again after 10 days by reflecting his name in the cause list so as to enable the learned G. Assam to examine the matter and address this code as to the reason for non-appearance of the respondent. This is- Item number 23, respondent number 6, Ms. D. D. Burman, learned counsel for respondent number 6 is present.
Item 26, 27, and 28.
Lordship, in this case, affidavit has been filed yesterday, Your Lordship, in all the 3 cases. On behalf of respondent number 1 and 2, affidavit in opposition has been filed yesterday.
Yes, Your Lordship, I received the affidavit, but I want to submit a rejoinder. Kindly allow some.
Mr. G. K. Gupta, learned counsel for the petitioner submits that counter affidavit filed by the respondent numbers 1 and 2 have been served upon him yesterday, and therefore he be granted how much time?
As you please.
No, you must say.
3 weeks.
3 weeks time to obtain instruction and file rejoinder. Mr.
D. Akram appearing on behalf of BK Singh, SCFCI.
Mr. B.K. Singh, learned standing counsel FCI is present on behalf of the respondents.
Oblige you.
These matters be therefore listed again after 4 weeks.
Item 29.
May please, Your Lordship, Sundar. No, this IA has been filed praying for keeping one post vacant. My lord, what happened in this matter? The petitioner approached this honorable court praying for promotion to the post of assistant engineer. My lord, there is a peculiar rule, my lord. If Your Lordships kindly take the IA, page 16, 67% quota of promotion to the post of assistant engineer shall be filled up by direct recruitment. Page 16, 7, Rule 7, promotion as assistant engineer from the post of junior engineer. 7A, if you for filling of the post of assistant engineer, 60% of total post of assistant engineer shall be filled up by direct recruitment.
What is the matter? Your client is serving as what?
A junior engineer, my lord. My client is serving a junior engineer.
In which department?
Town and country planning department, my lord.
Then?
And he is continuing as such since 2009 without any promotion, my lord. Then this rule provides that 60% of the post can be filled up, post of assistant engineer can be filled up by direct recruitment, and there is a proviso in page 17. It provides
Yes.
Second paragraph, my lord. Provided that.
Yes.
Provided that notwithstanding anything contained herein before in this rule subject to suitability, a planning assistant, overseer, subordinate engineer, junior engineer, I'm a junior engineer, computer draftsman, grade 1, planning draftsman, grade 2, grade 1, research assistant of Assam Town and Country Planning, subordinate service, on his acquiring the academic qualifications as prescribed for direct recruitment to the cadre of Town and Country Town Planning Assistant or Assistant Engineer or Assistant Research Officer shall be promoted as Town Country Planning Assistant, Assistant Engineer or Assistant Research Officer in consultation with the Commission as provided in para 10 against the next available vacancy in the cadre, and such promotion shall be treated as direct recruitment to the cadre of Town Planning Assistant, Assistant Engineer or Assistant Research Officer for the purpose of this para. So a junior engineer, if he is a bachelor, if he is a bachelor in engineering, so he can be promoted to the post of assistant engineer, and that will be considered as direct recruitment. Now there are vacancies in IA, I have stated. There are in as much as 5 vacancies, but they are not filling up. They are not considering my case for promotion, my lord. And now they are contemplating to fill up all the posts 100% by promotion. So that is why, my lord, this IA has been filed to keep one post vacant. Otherwise, my writ petition will be infructuous, my lord.
Lordship, in this case, this is the thing is that there's a difference.
Here the operative word is acquiring, your lordship. Basically what happens, junior engineers, they have diploma, your lordship. Then they acquire, if they acquire the degree, BE degree, then they get this promotion subject to the vacancies being there, your lordship. Here in this case, he had already acquired the degree earlier and then applied for junior engineer. And your lordship will turn to page number 10 of the writ petition. It is his statement that as per the interpretation that he's putting on the rules, he's saying that on the very day where he joined service as a junior engineer, he ought to have been promoted to the post of assistant engineer, your lordship, because he had already acquired the degree of BE, and therefore under this provision, he should have done that. That is the interpretation which he is placing, and based on which he has filed this IA saying that no, I deserve a promotion, this expedited promotion in this case, your lordship. So according to, if we go by that, your lordship, that interpretation will result in chaos, your lordship, because what will happen is that now the government will recruit for junior engineer. And anyone, if we follow his interpretation, if the petitioner's interpretation is followed, your lordship, then what will happen is that the moment they enter into service, they will say, no, now promote me to assistant engineer.
We'll see, but this is promotion to the filling up of which post?
Assistant
Assistant engineer, they are contemplating.
We'll make it subject to
Outcome, absolutely.
At least one post may be
No,
kept.
but what you compensate then if you don't succeed? Why should one post be kept vacant?
Otherwise,
You
my
succeed, you will
repetition,
be appointed.
otherwise my repetition will become.
That's why we are saying it will be subject to outcome of the writ petition.
They will fill up the post.
Oh, no, Mr. Das, you have to change your understanding of law. If you succeed, whoever is the last person to be promoted will go out, as simple as that.
That's true.
Then heard Mr. H.K. Das, Nanak, counsel for the applicant, also heard Mr. C.S. Africa, Leonard G. Assam appearing for the opposite parties.
All that.
The writ petitioner is presently serving as junior engineer in the Town and Country Planning Department in Assam. According to the applicant petitioner, he is eligible under the relevant service rules for being promoted to the next higher post of assistant engineer in the Town and Country Planning Department. Mr. Das submits that there are number of vacancies available in the rank of assistant engineer in the Town and Country Planning Department, which are required to be filled up by way of promotion. However, on an erroneous interpretation of the rules, namely the Assam Town and Country Planning Service Orders from 1990, the respondents are seeking to fill up all such vacancies of assistant engineer by way of direct recruitment.
No, by way of promotion.
By way of
100%
promotion. Without considering the case of eligible candidates such as the writ petitioner applicant. First of, it is also the submission of Mr. Das that since the petitioner has approached this court by filing the connected writ petition, being WPC number 3437 of 2023, seeking a writ of mandamus for considering his case for promotion. Hence, one post in the cadre of assistant engineer be kept vacant, awaiting the final order in the writ petition. Full stop. Hence, this IA. Full stop. Mr. C.S. Hazarika, Leonard G.A. Assam, on the other hand, submits that the interpretation sought to be given by the applicant writ petitioner is wholly erroneous, in as much as the applicant has not been deprived of proper consideration for promotion under the rules. Full stop. Therefore, the relief as prayed for by the petitioner is not maintainable in the eye of law. Full stop. Whether the assertion made by the petitioner on construction of the rules are correct or not can be ascertained only after the final hearing of the writ petition. Full stop. However, if the petitioner stroke applicant, you maintain same seriality, applicant petitioner ultimately succeeds in the writ petition, unless his interest is protected in the interregnum, the matter would be rendered infructuous. Full stop. In view of the above, infructuous. At the same time, keeping a post vacant indefinitely would not only pose difficulties for the department, but would also deprive the public of the services of an officer in the rank of assistant engineer. Therefore, balancing the equities and keeping the interest of the applicant petitioner in mind, it is hereby provided that in the event the authorities fill up, the authorities propose to fill up the vacant post of assistant engineer, the same be done only after giving proper opportunity to all eligible candidates to participate in the process in accordance with the rule. Full stop. Any promotion given to the post of assistant engineer during the pendency of the connected writ petition will be subject to the final order passed in the writ petition. With the above observation, the highest is disposed of. So if you succeed, you will get it as simple as that. Yes. So 5 minutes comfort break and then we'll come.
Lord, this matter has come on an application filed by us for correction on order dated 2012, madam. IA 3882/23, madam. The order starts at page 15.
Yes.
In the application, my lord, in which that order was passed, there were 3 applicants. Now, my lord, in the order only name of one figure, that is the correction we need. At page 26, my lord. Last page. There were 2 IAs. In our IA, my lord, there were 3 applicants. I'm reading, it will now be open for the authorities to permit the 2 applicants, namely Dr. Priyanka Chaudhary and Namointa Datta is fine. Priyanka is fine. Then along with Priyanka, there were 2 others, Saurabh Jyoti Roy and Debashish Mishra, my lord. These 2 names were omitted, ma'am. And these 2 names should be incorporated, ma'am. In the first page itself, my lord, their names figure in page 15, man. Priyanka Chaudhary, Saurabh Jyoti Roy, and Debashish Mishra. Inadvertently left out.
So there were altogether 4 applicants.
Yes, ma'am. In our application 3 and in the other application 1. 4.
No, just a minute. Just for understanding, how many applications were disposed of by the
2 applications, my lord. One is IA 1988. Page 15, your lordship will just come on, sir.
Yes, 1988. How many?
1983, 3. Priyanka, Saurabh, and Debashish. And there was another IA by Nabanita. That is at page 19. IA 2468 at page 19. There was the sole applicant, Nabanita.
Yes.
I don't have any objection, ma'am.
You are appearing for?
For writ petitioner 1 and 2, my lord, opposite party number 1 and 2. Writ petitioner.
And you are for? Okay, you take down. Heard Mr. B.D. Goswami, learned counsel appearing for the applicants. Also heard Mr. M. Datta, learned counsel appearing for the OP numbers
1 and 2.
OPs bracket rate petitioners numbers 1 and 2. Full stop. Miss A. Gayan, learned CGC is present on behalf of the OP number 3. You tell me about the OP, not respondent.
Oh, sir, OP number 6.
OP number?
16.
You're not for the Union of India, is it?
Yeah, I got it.
Appearing for the college.
I'll call some.
You are asking your junior
Yeah,
who you are appearing for. Take a appearance who's appearing on. This IA has been filed with a prayer to correct an inadvertent error occurring in the order dated
2012.
2023, jointly passed by this court, disposing of IA number IA bracket civil bracket close number 1988 of 2023 and IA civil number 2468 public 2023. Full stop. IA civil 1988 of 2023 was preferred by as many as 3 applicants, namely Dr. Priyanka Chaudhary, then
Saurabh Jyoti Roy.
Sri Saurabh Jyoti Roy. Is it Saurabh Jyoti Roy?
Saurabh Jyoti Roy. SAUR.
And Dr.
Doc-
Devashish Mishra,
Yes, ma'am.
whereas IA
246.
public 2023 was preferred by Dr.
Navanita.
Navanita Datta, seeking similar reliefs. First up, all the 4 applicants were selected for appointment in respect of the posts applied for by them and by the order dated 2012-2023. This court had vacated the interim order passed in the writ petition, thus permitting the applicants to join their respective posts in terms of their appointment order. However, while issuing the order dated 2012-2023, this court had mentioned the names of only 2 applicants, namely Dr. Priyanka Chaudhary and Dr. Navanita Datta, while inadvertently omitting the names of Sri Saurabh Roy and Dr. Devashish Mishra.
Saurabh Jyoti, ma'am.
Saurabh Jyoti Roy and Dr. Devashish Mishra. Hence, this IA for correction of the order dated 2012-2023. The learned counsel appearing for the opposite party submits that they would have no objection if the correction in the order dated 2012-2023 as prayed for by the applicants is permitted by this court. From examination, after examining the records, relevant records, this court also finds that there was an inadvertent error in the order dated 2012-2023 as pointed out by the applicants. As such, this IA is hereby disposed of by providing that the relief granted to the 2 applicants, namely Dr. Priyanka Chaudhary and Dr. Navanita Datta, by the order dated 2012-2023, shall also be extended to and applicable in case of Sri Saurabh Jyoti Roy and Dr. Devashish Mishra, that is the other 2 applicants in IA civil number 1988/2023, arising out of writ petition number
1635.
1635
1635.
of 2023.
Yes.
With the above observation and clarification, the IA stands disposal. Obliged.
Much obliged.
For hearing, I just heard it.
What is this matter?
Under the matter pertaining to the appointments for the computer assistants in the district of Goalpara by the High Court, Honorable High Court. The advertisement was issued, my lord, for appointment of that computer assistant in defined district of Assam, including Goalpara, and the advertisement is page 25-26. Okay.
Notifications. The 2011 poster earmark for the Goalpara district, my lord. Result of the computers, applied from the page 25 and 26. 25, 26, my lord. It is total number of vacancy all over Assam was page 25, my lord. 397, out of that 11 was earmarked for the district of Goalpara, my lord, which is in page 25 of the advertisement. In the last of the advertisement, my lord. The petitioner has applied, he is a certified PWD, my lord, and also OBC candidate. He has applied under the OBC reserve quota, my lord. Among the in the examination, among the Goalpara district, he stood first. That is the page 39. The result written examination. The number 9. His roll number was. It is page 39. His roll number was 19043. Mintu Roy. He stood first among the Goalpara district, my lord. And thereafter, he was the call for a written test and written test examination, my lord. Page 39. That is page 58 and 57. He stood first and then he was called for written examination. Yes, I called for written examination. I have API. I have entered for oral also, my lord. I have API. Out of that, but my name was, I stood first in the written in the Goalpara district, but my name is not in the final list. Thereafter, I have inquired in the registry, my lord. And registry has told that there is no provision for reservations of the PWD candidate, my lord. But in the advertisement, my lord, in the last it is the age of the 39 PWD page 26, my lord. And thereafter the registry has called for over phone his certificate of the OBC, my lord, and he was not in the PWD, there is no reserve quota for the PWD, and OBC certificate was called for, my lord. And he has submitted the OBC certificate. He has submitted OBC certificate to the registry, my lord. Registry, which is at page 96, my lord. Page 96, the OBC cert he has submitted. And thereafter, then it was found that his name is, so in the last final result, his name is shown as waiting list in the unreserved category, my lord. Not in the reserved category, but in the reserved category, the respondent number 3 and 4 was appointed, but their mark is more less than the petitioner, my lord. I'll come to the final result, my lord. Seventeen. Final result, the petition to registry from the final result is 73. The page, you will also kindly see the page 91, the final result. The name of the present petitioner, Mintu Roy, is 13. CL number 13. He has secured total 84 mark, my lord. Total mark 84. But the respondent number 3 and 4, who also reserve category, their name is in the page 21. Page 21, oh sorry, number 21 and 23. 21 secured 75 marks total, and the 23 secured 71 mark, my lord. But my candidate, the petitioner has equaled 84 marks, my lord. So there is no reserve quota for the PWD, and the certificate for the OBC was called for by the High Court. And as per result, he secured more mark than the respondent number 3 and 4 of the result. So he should have been appointed, my lord. In the Yes. Petitioner also belongs to OBC.
Yes, OBC, my lord. OBC and PWD both. OBC certificate was called for by the registry over phone, my lord, and he has submitted. It is in the page, my lord. 103 page. No, 96, my lord, page. Page 96, Annex 11. It is a certificate submitted by the petitioner as per call made by the registry, my lord.
Yes.
And the, my lord, in the advertisement, that he is the qualified PWD, it is in Annexure 3, page 29, his OBC certificate, my lord. Annexure 3, my lord. And the day after. And the.
Yes, so that's it.
My lord?
That is your case.
Yes, my lord. I OBC, I have secured high mark and I have not posted it.
Who is appearing for respond number 3 and 4?
Your lordship will kindly come to the advertisement for a moment, my lord.
Yes.
Page 25. Serial number 11, Gwalpara. Number of post 11, my lord. Page 25.
Yes.
Then your lordship will kindly come clause 12. That your lordship will find page 27.
Yes.
11 also, my lord. Any information submitted by an application in her application will bind the candidate personally. And if found to be false, she may be liable for criminal so and so. Then 12, a candidate will be responsible for any mistake made by her in the application form, and High Court shall not be responsible or liable in any way. Number 13, my lord, one candidate will be allowed to submit one application only indicating any one district of his or her choice, my lord. Now, the issue herein is that, my lord, if your lordships kindly come to page 93, the establishment wise sanction post. This was uploaded in the website, page 93. The vacancy position as well as, my lord, categorization of the post. Down below, my lord, Gwalpara, your lordship will find.
So, Mr. Das, what is your submission?
My submission is that, my lord, no post was earmarked for PWD candidate. Here only OBC was earmarked for under the reserve category candidates, only OBC was earmarked. So he submitted his application as a PWD candidate, but there was no reservation earmarked for PWD because 3% of 11 doesn't come, my lord. And
but he was an OBC candidate also.
At that point of time, we never know. After the entire selection was over, my lord, then he come up with this page 96 email, send this email. We have disputed that also, my lord, in our affidavit. We said we haven't received anything during the selection.
In his application, he did not mention that he belongs to OBC.
No. He only mentioned PWD candidate. I have stated in para 2C of my affidavit, my lord, and also at para 9 and 11 of my affidavit. It was a mistake committed by him, my lord, with all due respect, my lord. It's not that we have done some illegality, my lord. Had he put his, my lord, status as OBC, then things.
When did you come to know that he belongs to OBC?
Only after filing of the writ petition, my lord. Only after filing of the writ petition, my lord, this fact came to our knowledge.
And what about his claim that he had sent a copy of the,
No, first of all, that was after the
where is his application?
9 and 11, we have stated, my lord.
His application is available with you.
Which application, my lord?
Application submitted by him.
As a PWD candidate. Right now, I don't have, I can produce, my lord. I can produce.
One thing
But
I
it's
just-
an admitted factual position that he applied as a PWD candidate, my lord. That's why, my lord, he was considered.
No,
as
that is okay. That is another matter. But did he not mention that he belongs to OBC?
No, no. He did not mention, my lord. He only mentioned that he belonged to PWD. And page 93, your lordship will see there was no vacancy or post earmark for PWD candidate. We'll have to go, and that was uploaded in the website. Page 93 thing, establishment wise vacancy was uploaded in the website, my lord. Perhaps that he did not see that. It was a mistake that cost him, my lord.
One thing. Did the petitioner mention in his application that he was an OBC candidate?
I have not seen the application, but he has mentioned it. Your lordship kindly see that.
No.
Page
It
25. Page
will
25
depend
is
on
the
what-
advertisement.
Mr. Sharma, you have to answer the question of the court. Otherwise,
No, that is
you go on
application,
saying
not
whatever you feel like.
Application.
That this kind of hearings, this court will not be able to hold. You have to first answer the queries of the court.
I beg to point out one thing, Major.
Yes.
That is in a page 25, last page, they get categorized wise. The general candidate, 18 years minimum age, and the others, 18 years, and the ST, schedule type, 18 years, PWD, 18 years. There is this mention about the PWD, so petitioner is under impression that there is a reserve quota for the PWD, my lord. So he is a certified PWD, that is why he has applied the PWD candidate, my lord. It is there, my lord.
Where is the reservation provided in the advertisement?
If you, I can just take. It provides.
Where does the advertisement mention the?
No mention for it.
Huh?
In page 25, it provides reservation posts for different categories would be as per rules. Page 25, first para, last line. And page 93, we uploaded, which provides for the reservation of post in all the districts. Page 93. Down below, second last, your lordship will find Gwalpara.
This was uploaded before the.
Yes. This was uploaded before the selection. That we have stated in our affidavit also.
Now, when the OBC certificate was called for.
No, this can't be taken.
The registry has called for it.
That
And
they are
after-
disputing.
After receiving the same, after receiving
He
the same. it
is
was not
disputing
considered.
that. Mr. Sharma, he is disputing that. This is a disputed question of fact. Your submission is that registry has called for it. He has disputed it. Second thing, registry cannot call for this certificate. You have to mention it in your application. Otherwise, how does the registry know who is a OBC, who is a SC, who
It
is
is all from, I am given the telephone number also. The telephone number is there.
a?
my
Anyway,
lord, in
you
the
argue.
page.
Anything else you want to argue, you argue. If he has mentioned in his application that he was an OBC, your client will get relief,
Sir,
right?
the application needs to be produced.
All right, then produce, if possible, can you produce the application?
And just ask, look at the instructions whether it's available. If it's available, then I'll definitely produce.
If he has mentioned that he is OBC, he will get the relief.
Yes,
If not, we'll dismiss the writ petition.
yes.
Part third, list again on 23rd. I'm not mentioning anything else.
Fine,
Just
ma'am.
get the
Make it
application.
24, my lord.
I'll get it.
Make it 24.
24. Because we can't keep reopening matters like this. We had to be diligent. There was no reservation for PWD. All right, PWD, let's forget it. He has mentioned it's okay. But now he is claiming benefit as OBC, not PWD. If he does not mention it in his application that he is an OBC.
My lord, one more thing, all
From
throughout the
the-
selection process.
From the advertisement, he was under impression that there is a provision.
His
for
impression is
PWD.
his problem.
Because it is mentioned
We are
here.
not concerned with his impression. We'll be concerned about whether he has been discriminated against. What his impression is, what he thought, these are not questions for the court to go into. If he has been wrongfully deprived, we'll grant him relief. But if he has not mentioned, he wants government job, he should have been careful. On what basis do we set aside the appointment? To grant him relief, one of their selection and appointment has to be set aside. Why should he give him a premium for his mistakes? Why? Why should he give the petitioner a benefit for his mistakes?
His mistake is, my lord, he was under impression that.
There was a mistake.
Reservation for PWD.
Oh, Mr.
In the
Sharma.
PWD candidate, my lord.
His impression is his problem, none of
But as
anybody.
per their advertisement, my lord.
Hmm.
As per
Anyway,
advertisement.
you
in the
get
PSL
us,
here.
get us that. and
Yes,
then we'll
can
talk.
it be on 30, my lord? 24, some difficulty, my lord. If not in
30th?
this tarikh, this tarikh,
30.
30. All right, 3.
But that's the law. There is nothing much to
Well,
argue here.
PWD is mentioned there, that so he thinks that there is a reservation for PWD, and as per rule also, provision for PWD should be there.
It was a wrong impression. We'll mention in the order that his impression was wrong.
But
That's
as
all.
per, we have mentioned that as per.
Is
rule-
he enforcing his
No,
impression?
reservation policies as per rule.
Hmm.
So as per rule of the PWD candidate, there should be reservation. And I have
But
mentioned. the-
subsequently, they have
I have
given
mentioned the
it.
rule.
Mr.
Yes.
Sharma, the problem is you don't seem to listen to the court. You want to say whatever you feel like. If you want to say that, you say it. We'll write whatever we feel like. When the court is interacting, you are not even giving any importance to what the court is saying. You are again and again saying it is his impression, it is his impression. How does the court care about his impression? His impression is none of our business. We are only trying to figure out whether he has been wrongfully denied of a proper treatment by the authorities. If he has been diligent, if he has applied with proper care, and then they have discriminated him, we'll grant him relief. What his impression is, what he thought is none of our business. That was a wrong impression. He is responsible for his impression. He cannot enforce his impression in the court of law. Has he applied as an OBC candidate? If not, we'll dismiss the writ petition. Part heard matter. Yes.